it's funny that like, but you can also see that he tried to intentionally hide that he was copying from Kiwi Farms, because when you look at both of these images here are images hosted on Kiwi Farms. He remembered to transcribe this first link. He transcribed the first link to hide where he was stealing his testimony from, but he forgot to transcribe the second link, and he left in the copied pictures for both, right? You see this here? So on this first one, he managed to cover his tracks, but on the second one, he f***ed up and he left the original link to the expert witness, by the way. And remember, I'm not showing you this from an email. I'm not showing you this from like this is a public court filing that's available on Court Listener. If you've got a Pacer account, you can look this up. This is like, item 139, attachment 1 on the docket. It's just insane to me. But finally, I note the following. This is a forum that constantly talks about being raped and molested and calls me all sorts of horrible names and docks and harasses people, sends threats, like all the fact that she's just like, I just hate the fact that she's just like frolicking around doing whatever irrelevant shit she's doing with her life right now. I don't even know if she follows any of her court cases anymore, if she gives a fuck. And it's just like doing whatever, meanwhile, I have to like respond to all of these things. It's incredibly time consuming. My career is basically on hold until this like gets figured out, because I don't expect anybody to read through all these filings, but it's just like a huge joke to her and all these people, and it's wasting the court's time. And supposedly, this is a chick who wants to go to school and be a law student. I was like, okay, whatever. Finally, I note the following. Bunnell states that the original file name of the video, as revealed by several tiny leaks, is not the same as either of the file names that he sent to ABMC. That proves that he never sent the video to ABMC. But Bunnell is comparing apples to oranges because the two file names in ECF 132.6 that he purportedly sent to ABMC on November 3rd, 2023 are not file names. Instead, they're Google Drive URLs, which merely point to unknown file names. He's bringing this up. That's not the argument that I make, though. The argument I make is that the exact same Google Drive link is sent to two different people, and one of those people proves through their messages with me that it is of them and not of the defendant or not of the plaintiff. That's the whole point of this. So he either didn't read it, misread it, or whatever. Under penalty of perjury, I declare that I've read the foregoing document and the facts stated in it are true to the best of my knowledge and belief. And then, yeah. Why does it matter that he got the info in Kiwi Farms? That has to be the best place to get information because I'm obsessed there. Why does it matter? Because he's testifying to the veracity of my evidence as an expert witness. If plaintiff wants to state, we read on Kiwi Farms that they said this, then state that. But you can't pay an expert witness to give your own bullshit testimony. That's not how that works. Like, let's say that I say, I know that plaintiff has been using psychological warfare against me and is using actual black magic spells to attack me. And then let's say I pay an expert witness. I'm like, can you just like write this in there? Say that you're like a CIA expert and then just like write what I'm telling you. You can't do that. That's not the point of a expert witness. So he perjured himself. I don't know if it counts as perjury. I would say, I can't say I would say because I don't know what counts as perjury now, but yeah. But anyway, that was their expert witness thing. I just spent so much time going over all this and like writing up a huge ass bullshit for this. Just so unbelievable. Not only that, but also as quick lulz, this was filed 2 days ago. He filed an amendment saying, it's come to my attention that in paragraph 17 and 18 of my October 3rd, 2025 declaration, I made a conclusion of tampering based on defendant's incomplete and faulty document production. These documents produced, so he admits here that, actually I was wrong about the whole Discord timestamp thing. Imagine an expert witness amending their statements like 3 days later. But actually, this is how Discord messages work. Fucking moron. Is your writing going to be an outline for your lawyer? No. When I write up stuff, it's just to like explain to them like this is what he's saying, and then this is why it doesn't apply here, and then here's like my evidence to showcase that, and then it's up to them for how to format that in a legal brief, or how to format that, or if they need to bring in somebody else or whatever. Are we allowed to respond to the response? I believe we get one response to this response, and then it goes to and then the judge has to decide. But anyway, okay. So that was their expert witness testimony that they have as part of their motion to, their response to our motion to dismiss. Now remember, their response, I would think, I don't know if a lawyer in chat wants to say different. I would imagine that because subject matter jurisdiction is on the table here, I would imagine that their response, what they really should be trying to do, like, it's pretty stupid that 8 months into this case, subject matter jurisdiction is still on the table. What the fuck? Like, this should have been established way long ago, that you'd be doing everything you can to establish beyond any doubt. Of course, the court has subject matter jurisdiction over this case. Obviously, the court can hear this case. So if you spend the entire response to our motion to dismiss to just fighting on my evidence, okay, but you haven't done anything to establish subject matter jurisdiction for yourself. This is where you bring up your evidence. Tell us why the court should hear this case. You don't have to attack the credibility of anything that I say. It's a 12B1. This is a motion to dismiss, dog. The judge is going to read anything you say is basically true anyway. So why, you don't have to attack my shit. He's going to read your shit as true. It's not even a most favorable reading. It's just reading it as true. So why are you even responding to this shit? This is like a motion for summary judgment response. In my uneducated opinion, whatever. But okay. All right. Argument. Defendant's factual challenge must be denied because jurisdiction and the merits are intertwined. So this is just them saying that, like, obviously, if there's a factual dispute, if this is a factual dispute, then you don't have, the judge shouldn't really resolve it. That's for a jury, or at the very least, is a motion for summary judgment. They kind of like talk about that here. The court may not resolve factual disputes or weigh competing evidence on the 12B1 motion. Wait, what? Why do I have a mosquito in my room? That's impossible. Okay. Did I let him in yesterday? Oh, he's dead now, motherfucker. Okay, wait, what is this guy? A forensic image from Destiny's PC could be helpful in that whole case. It's no problem to find evidence someone has accessed files while he was out of town. Wait, what are you talking about? Apparently, there's a Discord cache viewer that can work on some files. At least, so apologies for parts. Be funny. Okay, I don't know what they said. Okay, all right. Anyway, defendant's factual challenge as premature. Since defendant's jurisdictional argument challenges the merits of plaintiff's claim, and discovery is in its early stages, they want to keep saying this. Okay, I don't know what the fuck else they think they're going to find. It is prudent to deny the motion without prejudice and decide the jurisdictional dispute at the summary judgment stage. This is kind of true. Generally, you wait to summary judgment, but again, this motion to dismiss, we're filing this is pretty late into the like discovery, I would say. So maybe the judge will consider some of the evidence brought up so far, but he doesn't have to. Here, defendant's jurisdictional challenge turns on disputed factual issues that require discovery to resolve the timing of disclosure of plaintiff's video to Rose, including whether it remained accessible to Rose and the public after the effective date of the Cardi, or of Cardi, as well as whether or not he disclosed the image to ABMC. Again, how are you going to do discovery on my end for this? ABMC, this is your witness. You should have the information. What are you hoping to discover from me? Why? It's your witness. Why are you asking me about it? What the fuck? Yet, discovery in this matter is far from complete, and the evidence relied on by defendant to support his argument is not reliable and cannot be authenticated. Plaintiff cannot fairly be required to meet her burden of proof without the opportunity to complete discovery. Because Rule 56 presumes that the parties opposing summary judgment had a fair chance to complete discovery. Blah, 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 blah. This is all just about like the process and procedure. Wait, did you see Legal Minds had a tech expert on to confirm everything that Pixie's expert said? If you really want, you can link me the timestamp on that. I don't want to go through this whole thing. I try to watch a little bit of them, but like I said, I don't know why, but I like everybody that looks at my shit gets so brain broken. They just start giving the dumbest like summaries or conclusions of everything. So yeah, I don't know. If somebody wants to timestamp me his expert, then I mean, I can go through some of what he's saying, but I'm very confident in what I'm saying. I'm 100% confident in my analysis. You don't even have to know that much to understand that how stupid what that other guy's saying is. Wasn't there talk at one point that someone might have used your PC while you're there, that this person might have sent local... Oh, Hallie. Oh, I don't know, maybe. But the problem is, I don't even think I have the same computer that I had, because that would have been like 2 years ago. And I've made like tons of upgrades and hardware swaps and everything else. So like there's no guarantee that I would have evidence of any of that kind of like transfer anything else. However, you know who would? Oh, but she wouldn't show evidence against herself. The problem is that like the ABMC person has no evidence at all either. Like, I can't like go over the hearing because it's still like waiting for the judge to rule on the ceiling. But they admitted it when we were in court. They said that they haven't seen any evidence. Abby didn't show them any evidence that I sent her anything related to this. So they've already said it. So that means Abby has nothing. And it means they have nothing. And I have nothing. So I don't know what they're expecting to magically be conjured out of thin air if nothing is presented to this point, right? And keep in mind, for all this talk of like forensic cryptographic hash analyses, the only evidence that we have of anything is Abby talking shit to a friend, supposedly. But like that message, one, has been doctored. You can see that something's been removed from the middle. It might have just been a random message. And then two, it's all like censored and edited. So I don't even know who she's talking to or if it's her account talking. And three, by the way, this is against the Federal Rules of Civil Procedure. I don't even have an unredacted copy of that exhibit. They haven't even sent us the unredacted. I don't even know what any of that is. I don't even have the original copy of it. So it's like, what you're not supposed to do. But anyway. Alternatively, even if the court were to convert Bonnell's Rule 12b1 motion into a motion for summary judgment and not defer ruling to after discoveries, this is all just about genuine disagreement in fact. At the outset, plaintiff objects to defendant's reliance on exhibits B, C, D, E, and F to Bonnell's declaration under the Federal Rules of Civil Procedure because these materials cannot be presented in a form that would be admissible in evidence. Like, again, I'm sorry, I'm reiterating this. I'm like fighting digital ghosts here. They're taking so much issue with all of my, I would say, meticulously kept logs of everything, okay? Because keep in mind, I could also just say, I have nothing, by the way. I could just say, I deleted all this shit way before any lawsuit happened. And they could accuse me of lying if they want. They'd have no proof of that. They don't know what the fuck I'm deleted or not deleted. I did genuinely delete a whole bunch of shit in terms of, like, I basically deleted every single message that I sent after all those Rhodes leaks prior to January 1st, 2025. I just, because I don't know who's going to fucking access whoever's Discord account or whatever. But I kept logs of everything I deleted, right? The only reason we're even able to have this conversation is because I kept those logs, which I had no legal obligation to do because I wasn't on notice of any fucking lawsuit on January 1st or prior to that. I wasn't on notice for any lawsuit until the end of January. So I could have just deleted all of it and then said, oh, I don't have any logs at all. I lied. And now we would just be arguing over what? Over stuff that's solo posted online? You have nothing else. So the fact that they're trying so hard to nitpick at all of my evidence, okay, that I really didn't even have to keep, with no evidence of their own, with nothing, with absolutely nothing. Based on all materials and communications produced by the defendant, including these exhibits, he embarked on a do-it-yourself search to preserve, authenticate, and produce documents, but failed to adhere to the cornerstone principle of digital forensics, forensically sound data preservation. So again, I mean, I'll be honest in that, like, I'm not like a forensics investigator, but like, I'm fairly confident when I say this, there is no world where any forensically sound data preservation can be done where the accused is the start of the chain of custody on the evidence, because I can always edit or delete or change things prior to hashing any kind of like value. Like, I don't understand what forensically sound data preservation would even look like from an accused's point of view. If the chain of custody starts with me, I can always doctor stuff. So I don't know what the fuck this point even is. I don't know how I'm supposed to even engage with this. It's such a stupid, self-defeating argument. Specifically, the essential step of generating cryptographic hash values at the time a collection was omitted. I feel like they find like a new tech term to use, like every 15 motions. They've like watched a new episode of Law and Order, and then they find like a new term to start throwing into their filings, but just stupid. These hashes are unique digital identifiers that assure integrity. Without an initial hash rate to compare against, any subsequent analysis, blah, 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 the defendant's mismanagement of the ESI effectively breaks the chain of custody, preventing any reliable verification that the evidence remains in digital state. Like this, what? The chain of custody starts with me. What is the point of any of this? This is so stupid. Moreover, the documents bear indicia. How do you pronounce this? Hold on. Indicia of alteration and tampering, and cannot be properly authenticated under the federal rule of evidence. Such tampering constitutes spoliation and, at a minimum, creates a genuine issue of material fact as to the reliability of defendant's submissions. Where credibility and authenticity are in dispute, summary judgment is inappropriate because credibility determinations, weighing evidence, accordingly, on this basis alone, defendant's motion should be denied because it rests on inadmissible, tainted evidence and raises material, factual disputes that only a jury can resolve. Plaintiff reserves all rights to seek sanctions or an adverse inference instruction arising from defendant's misconduct. Sanctions here, an adverse inference instruction means what they're saying is, jury, since we can prove that defendant tampered with the evidence, you're allowed to read that maliciously if you want. What an unbelievably stupid thing to say, that you can have an adverse inference from my discovery that I've kept, that I have produced in any form the fucking plaintiff has asked for. And meanwhile, on their side, they have engaged in spoliation. I've shown that she's deleted and edited messages after the fact, and then imply that I would be the one to get the adverse inference here when they have no evidence on their own. They literally have no evidence. They literally have no evidence. There are disputed issues regarding Bonnell's disclosure to Rose and whether it was within the ambit of Cardi. Defendant claims that the disclosure of the video to Rose fails to establish subject matter jurisdiction because 1, it occurred prior to October 1st, 2022, and 2, the continuous accessibility theory fails. As a matter of law, both of these arguments fail. The court has already determined the defendant's evidence regarding the disclosure to Rose is murky at best. So this quote that they're pulling here comes from, I don't know if it comes from a motion or the judge, but like, this was an evidentiary hearing on the preliminary injunction. I don't think the judges had like a serious go through of all the evidence of this yet because it wasn't like the central point. So I feel like this is dumb. It's from the magistrate judge. Yeah, like I don't think that he's doing like a hardcore deep dive into the, the magistrate judge. He was the one who heard our hearing. Of the evidence regarding these timestamps, because I think that a fair reading of like what's being produced, it's not murky. The timestamps are not murky, and actually, and I'll show you later on in this, that even they don't think that the timestamps are murky because they try to have it both ways. None of the evidence presented in defendant's motion regarding the timing of his disclosure to Rose is new. The same evidence has been presented to the court numerous times. Indeed, the court has already reviewed the same evidence and held that, quote, the evidence establishing a definitive timeline as to what defendant did or did not do and when is murky at best. That's quoting from when they were amending their initial motion, their initial complaint or whatever. The judge's comments. The court also noted that noticeably absent from defendant's arguments generally regarding subject matter jurisdiction is testimony from Rose that would corroborate defendant's characterization that incorporates in Exhibit C a screenshot from Rose's Discord account, emphasis added. So I don't think the judge realized this, but the original screenshots that were leaked online were from Rose's Discord account. I don't think he realized that at the time. But again, we weren't like hashing out like hardcore, I guess like the veracity of that evidence. Remember, it's hard to do this because I have all of my evidence. I've got everything that I've kept. And then I've got the logs posted on Kiwi Farms, but they have nothing. I'm just like fighting, like they're just nitpicking my evidence, and I'm not fighting against anything. I don't know, like nothing that I've posted, nothing that I've shown defendant or plaintiff disagrees with anything. So somebody in chat said discovery still needs to happen. This is just to see if you together. No. We're deep into discovery. I would say we're probably done with it, depending upon how much the plaintiff wants to continue hiding from me. But we're basically at the end of that at this point. The only thing that I can say, oh yeah, because these are public, is both of us still have to do depositions, which they're also fighting on because they want to fight on everything. But yeah, we're at the end of discovery at this point, unless the plaintiff is actually going to turn over anything, which they, I don't know. Despite this clear directive from the court, defendant failed to submit any corroborating evidence from Rose and instead simply submitted the same evidence and arguments that the court already rejected. Thus, there is no need for the court to revisit this issue. On this basis alone, the court can deny the motion. So again, Rose's logs were the ones that were posted on Kiwi Farms. This is my favorite thing. So again, Pixie's whole point is she just wants to like reputation attack me as much as possible. So she has this in here, okay, our pedophilia arguments. In fact, it is plaintiff, not defendant, that has made efforts to obtain evidence from Rose. So this all here is a fucking lie, okay? Plaintiff hired a private investigator to ascertain Rose's legal identity and location, and has just this week managed to serve Rose with a subpoena, Deuces Tecum, I don't know what this means, to appear at a deposition. So the stuff that they found, it was just the Kiwi Farms traffic ticket. You hired a private investigator to dig up the same thing that Kiwi Farms dug up? Bullshit, right? This is bullshit. You found the thing that Kiwi Farms is posting that is claiming, and might be, the person. This is not the long search of a fucking private investigator, okay? After finally ascertaining Rose's legal identity, plaintiff has obtained evidence that Rose's date of birth is October 30th, 2004. Thus, when Bono was exchanging pornographic content with Rose between March 2022 and until October 30th, 2022, Rose was a minor. I like how they're rolling with this, right? So we have to stick this super juicy fact in here. I like how they're rolling with this, saying that I was transmitting material to her while she was minor, but then they're also saying we actually have no idea when any of the material was being transmitted, what? This is like Schrodinger's fucking birthday. So like I'm sending her stuff, I guess if she's underage, but also at the same time, we have no idea when I'm sending stuff. Which one is it? What is the... really, I don't know, really makes you think. There are disputed issues of fact regarding the date of disclosure. Defendant relies on a comparison of two documents as the sole support for the assertion of evidence. Conclusively established the video was transmitted on April 9th, 2022. At 8:36 p.m. Yet the Discord chat thread does not show any transmission of the video at 8:36, and it actually contradicts that contention. Well, they know that I've already deleted this video. I've already told that to plaintiff, and Destiny, what does this have anything to do with their case? Even if she was underage, wouldn't that be a separate criminal issue? No, none of this has anything to do with their case. Remember, the whole goal of anything in this lawsuit is to throw as much in as she possibly can to fuck with me. That's the only goal of all of this. Because realistically, they don't really want Rose to sit for deposition because what is she going to prove? It's not like Pixie knows that this video was sent before the Cardi cutoff. So there's nothing from a deposition that they could even gain that would help for their case. Also, I seriously doubt that whoever this person is, I seriously doubt she's going to want to sit for a deposition because in the best case, this just has stuff that she doesn't want to deal with. It just further, fucks her real life up. And then at worst, it would really fuck her life up. So, I don't even know if this person will respond to this. But yeah, the Discord chat thread, and the Discord chat thread, so they're relying on the, oh shit, I didn't even connect this. Oh, that kind of sucks. So this part of their response to our motion to dismiss is relying on stuff that Jesus himself came out and said was incorrect. Fuck, wait, I hope they caught that. Bop, 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 bop. Sorry, hold on. Page 7 and 8. How likely is it you say Hassan is bankrolling Jane Doe under the table? I would say almost no chance. I would be shocked. Okay, sorry. Still reading through. There are also contradictions in Bonnell's declaration submitted to the court about the date of his disclosure to Rose. In Bonnell's April 25th, 2025 declaration, he claimed under penalty of perjury that the reason the leaked screenshots had a European date stamp is because it is a screenshot from Rose's side of the conversation, and Rose is corresponding from time zone 5 hours ahead of me in Miami, Florida. Defendant now claims, without providing any explanation for his directly contradictory assertions, that it was not Rose that was in Europe at the time of the disclosure, but rather it was Solo Tiny Leaks who was located in Europe at the time he accessed the video and other material from Rose's Discord account, such that the timestamps are reflected in the standard European format. Bonnell provides no evidence to support his new contradictory assertion that Solo Tiny Leaks was in Europe. Thus, Bonnell's explanation for the different timestamps is nothing other than sheer speculation. The date format is European. I don't know what you want me to say. Unless you guys are arguing, because in their own exhibits, I'm too lazy to scroll back and find them, they have screenshots where the dates are like 27-01-2023 or whatever. And it's like, do you believe that there are 27 months in the year? It's obvious that these are in European format. And all of my evidence coincides with it. And your little pedophilia snipes in your lawsuit also rely on it being prior to October. What? This is not a seriously contested fact. I don't understand why. One theory that I had was maybe their goal is to fight so much that it goes to trial, and their goal is to try to settle with me right before the trial. Hey, if you go to trial, it's gonna cost you a few $100K more. What if you just pay us $80K and then we'll be, maybe? I have no idea. Cause at this point, I don't think I can do it. But like at this point, like I'm almost tempted to tell my law firm, can we just like not respond to anything? Let's just go to trial. Fuck it. Like why not? Like I've already, balled out this hard on all the fees. At this point, maybe it would be fun. We could sit in trial and we could have it all fucking hashed out. I want to hear Abby talk about me sending this video with no evidence. And then I want to be able to ask her a question about, weren't you in my house taking pictures of my computer, telling people major leaks incoming and sending pictures of my wife's fucking diary to your friend? Like I want to talk about all this. Let's fucking do it. Why not? Yeah. Fucking let's go. People are saying it would be dank meme video, but it wouldn't. It's federal court, so there's no video. You're not allowed to video record any of the federal stuff, or there's no live stream or anything. Anyway, sorry. Okay. What is this? Hold on. Ali Cattails. What do I recognize this name? If only Discord could be subpoenaed. Discord only has, oh, this person's retarded. Never mind. Discord only keeps logs for like 30 days. Everybody thinks that every single like company keeps logs infinitely for every single thing. That's just not true. Especially with the GDPR now. You can't keep information indefinitely on your stuff. I think Discord only has stuff for 30 days. This idea that there's some master archive or master record of every single thing ever sent is just not the case. And then somebody says, because you haven't, and she also said, because you haven't proven it definitively, an expert you hire could. Nobody can definitively prove the origination of a digital file. You can't do that. It's a digital file. It's zeros and ones. You can create bit-perfect copies of it and send it anywhere. There's no way to definitively prove where it originated from. Well, that's not entirely true. Like you could, with a high degree, almost definitively prove like the camera or something that might have taken a file initially. So maybe you theoretically could, but in that case, the origination is just going to be the phone that I originally recorded it on. That's not going to provide you any relevant information, right? Because we both know that the phone that I originally recorded it on, that's not going to tell you anything relevant for this court case. Okay. Let's see. Okay, so we're still trying to play games with the date format. Also, keep in mind too, because they're responding to our motion to dismiss the whole case, okay? Keep in mind for this, they are not, I don't know if they provide any evidence anywhere in their motion to dismiss response. This is a summary, or this is a subject matter jurisdiction challenge. We're saying the court can't even hear your case. It is an invitation for you to provide any evidence whatsoever that you have to just show the court that they should be allowed to hear it. And they provide nothing. All they do is they use it as another example to needlessly nitpick my shit. And they bring in a forensics expert, not to show that they have evidence, but to just needlessly nitpick mine, some of which he's already walked back like 3 days later. What are you doing? What the fuck are you doing here? Accordingly, there are disputed factual issues regarding the date of Bonald's disclosure to Rose, and defendant's motion to be denied on its basis alone. The evidence legal precedent established by Bonald's disclosure to Rose made the video accessible after October 1st, 2022. This is just their continuous publishing argument, which is all stupid. Nobody believes this. It's never been held up in court anywhere. This is just the dumbest thing ever. I will say that it's fairly funny that they rely on they make this whole public CDN bullshit. It's just stupid, publicly indexed. And contrary to defendant's assertion that Discord attachments were not publicly indexed or searchable, search engine indexing crawlers from Google, Bing, and others did index the Discord CDN servers. No, this is just not true. Jesus says this. It's a lie, or he's just stupid. It's important to know that Bonnell could have deleted the video attachment. It doesn't matter. Defendant's arguments continued accessibility fails as a matter of law. It's premised on two factual contentions, blah, blah, blah. Doesn't matter. Okay. Whether or not defendant disclosed the video to ABMC is a disputed issue of fact, preventing summary judgment. Even assuming, arguendo, that the disclosure arose before October 1st, 2022, and the disclosure did not make the video continuously accessible after October 1st, 2022, subject matter jurisdiction can still be found based on Bonnell's disclosure to ABMC after October 1st, 2022. Viewing the facts and evidence in the light most favorable to plaintiff, the evidence establishes that Bonnell did transmit the video to ABMC, or at the very least that this is a disputed issue of fact requiring further discovery and preventing summary judgment. Moreover, the evidence submitted and relied on by Bonnell for his assertion that he never sent the video to ABMC appears to have been tampered with and thus is unreliable and admissible. Remember, Abby has submitted zero evidence and has shown them zero evidence that I've ever sent her any of this video. So stupid. Bonnell, and then like this argument, how am I supposed to prove a negative? Like I gave them my entire conversation history with Abby. I gave the whole thing, okay? Bonnell fails to establish that he never transmitted the video to ABMC. Bonnell claims that his preserved communication logs to ABMC conclusively established that he never transmitted the video at any time, but these preserved communication logs are nothing other than an Excel spreadsheet, purportedly including all media files sent to ABMC, created by the defendant for the purpose of his motion, as well as a purported chat thread between him and ABMC. Yeah, it's just a file of text. It's a text file. What am I supposed to? Yeah, that's all it is. What do you want? Preserved logs might have consisted of a copy of his Discord exports in an HTML file, but instead, this is merely evidence artificially created by Bonnell. I mean, like all evidence is artificial. What do you mean? If I import an HTML file into a Google spreadsheet, it's still an HTML, like it's just text. Anybody can right-click and edit a text document at the end of the day. This is such a stupid argument. There is no way to verify whether the list of media files sent to ABMC is complete or accurate. Therefore, the evidence should be disregarded. Okay, then have her provide something. Who am I arguing against? This is my record of everything. Okay? This is my record of everything. She has no records of anything, apparently, and no evidence that anything I'm saying is wrong. What am I fighting? I'm fighting against digital ghosts. What am I fighting? I don't even know what I'm supposed to... How am I supposed to prove a negative here? What am I supposed to say? Is it necessarily the case that defendant is, plaintiff is rich as fuck? Couldn't it also be that she's picking the most cheap bargain bin lawyers and so she can stretch the 50K as power? No. This is more than 50K's worth of filings at this point, especially with the expert witness they brought in. So she's either, her parents are probably wealthy is my guess, or they're wealthy plus it's a family friend who's doing it on discount, or she found a bozo law firm to take it on contingency with the assumption that they would get a huge payout from me, but that doesn't really explain all the behavior. I just think her parents are probably they're probably like normal, like upper middle class-ish wealthy people. So like they've got like a decent house or whatever, and they've got like anywhere from $1 to $10 million in 401k savings, whatever bullshit. That's my guess. I don't know. I can't explain otherwise, like where all the money is for this coming. Yeah, the entire law firm basically that they brought in as lead counsel is like a Puerto Rican immigration attorney. So. There is no way to verify whether this list of media files sent to ABMC is complete or accurate. Therefore, like, there's no way to verify anything. These are all just files at the end of the day. What are you gonna, like, what the fuck? The evidence presented in ECF 132.6 should also be disregarded because 1, it is inconsistent, and 2, there's evidence of spoliation. A comparison of the timestamps and Google Drive file identifiers and the two URLs from the chat thread do not match the same from the spreadsheet list. The defendant, they're relying on that Jesus' stupid argument here because of the transcription of the files and the VT as a W or whatever, or as a V/, stupid. Because of this inconsistency, the evidence does not support defendant's argument. This inconsistency also indicates the evidence has been tampered with, and thus it cannot be considered by the court. There is more evidence of tampering. The two Google Drive links that Bonnell purportedly sent to ABMC and Peach in the two chat threads are actually not the same links. Because of this transcription error. See Declaration of Jesus demonstrated the myriad differences between the links. Myriad! Thus, defendant's contention that the videos he sent to ABMC were the same videos he sent to Peach and allegedly were videos of Peach and not a plaintiff is unsupported. Further evidence of spoliation is Bonnell's admission on a live stream on September 8th, 2025, that these preserved communication logs were artificially created by him. Quoting me, I guess. Information is lost. There is no original file. I'm trying to reconstruct a file. I'm artificially creating a file by reconstructing a log of stuff. That's what I'm trying to do, and it's not working. The only thing I'm talking about here, when I say information is lost, what I'm saying is like trying to make the timestamps line up between these Unix time codes is annoying because I can't tell if it was in daylight savings time or not. Like, I have all the original, but like even me saying I have like the original files is pointless. Like I could just shoot them the original CSV, but the problem is I have to make stuff presentable to the court, right? So on Redact, I have my original exports of my redacted information, and then on Discord, I've got my Discord logs of their side. But if I just show them like, well, here's the Redact logs and here's the HTML file from the Discord export, you would have to like go back and forth between the both, and it just doesn't read well. Like I have. Again, like all the plaintiff has to do is request both these files, and I can provide both. In fact, we might have already provided both. Like, I have all of the quote-unquote original files, but if you think I'm going to tamper with evidence, I could just tamper with the exports from Discord as well. It's just not proving anything. And also, if you think that I'm lying about anything, then just demonstrate a single thing that I've actually tampered with. Show a single thing where I've edited the information, and then the other side's like, oh, look, we proved that he fucked with something. That has not happened a single time, ever. It's like such a stupid argument. It's so dumb. Okay. Sorry, we're almost done with this. Bunnell also admitted to using artificial intelligence to format data into the Excel spreadsheet file because I asked ChatGPT to convert a whole batch. Oh, but it's funny because at the end, I didn't even use ChatGPT anymore for converting timestamps because that one Unix to... this website actually has a batch converter that I noticed on another page. Oh yeah, right here. But again, if you think I'm fabricating stuff or making anything up, then just show it. Because remember, plaintiff still has their side of the logs. They still have everything on their end, so they can show if they think I edited or modified anything, just show it. Additionally, Bunnell contends that because the original file names of the video is revealed by self-telling links, not the same as either file names into ABMC. That proves that he never sent the video to ABMC. But Bunnell is comparing apples and oranges. Oh, they're copying more Jesus' argument here. Stupid. Defendant also claims that ABMC only saw the video because she allegedly snooped through his computer on September 5th, 2023. This is a purely speculative claim is belied by ABMC's declaration and the evidence of her conversation with her friend. Okay, where is she? Why haven't we been able to depose her? Why is she not responding to any of our subpoenas? Why is she actively dodging service? Why is she giggling and laughing about it publicly on streams? Attesting to the fact that she received the video via a Google Drive link on or about November 3rd, 2022, 2 months later. Defendant's speculative claim is nothing other than an attempt to malign the witness. Okay, well, they're literally her own messages, so I'm sorry if she's maligning herself. ABMC's declaration of conviction not be disregarded. Defendant again attempts to challenge ABMC's declaration and the screenshot exhibit, but these arguments once again fail precisely because of defendant's spoliation. Bunnell claims that ABMC's declaration and the exhibit should be disregarded because she failed to provide evidence of the disclosure, i.e. a screenshot of a message which Bunnell supposedly sent the video to ABMC. However, Bunnell knows that ABMC cannot do that because Bunnell deleted all of his direct messages to her sometime in early 2025. That's a lie. I'm pretty sure I wiped my messages with her way before that. I think it was like on the, it might have been after her car accident or something. But it was way before this. But also, if you're telling me that she has sent messages to her friends claiming that I've sent all these videos, she doesn't have anything in her internet history showing that she accessed these links. She doesn't have a screenshot of any of the links provided. She doesn't have a screenshot of any of the material I sent her because, by the way, Abby definitely sent screenshots of explicit material that people have sent to her. I have lots of evidence of this. So I know that that's not the case, right? So you're telling me that she doesn't have a single shred of evidence of me sending her anything except that one message? Bullshit. It's a fucking lie. I don't know why I'm arguing this. I know it's a lie because I have never sent her this. It's just a lie. ABMC's declaration dated April. Also, we're 8 months into this court case. Why, we're 8 months into this court case. Where is she? How do we not have her deposition yet? How do we not have any responses to any questions yet? What are we waiting for here? Discovery closes in 2 months. I recently reviewed my Discord account and realized that Destiny deleted all those messages to me. I've retained copies of my messages. Destiny's my messages to other people about his non-consensual sharing of sexually explicit videos. Multiple other women who received explicit content from Bunnell also attest to his deletion of their set of messages thread after the November 28th, 2021. See the declaration from Hannah Brooks, as noted above. What a piece of shit. This all is so funny. As noted above, it has been publicly acknowledged there is no original file, i.e. because he deleted it. And as noted above, he has publicly acknowledged that there is no original file, i.e. because he deleted it. No, because there is no original file. What do you mean? Everything is a derivative file. I don't have access to Discord servers. All I have are my own exports from Discord. There is no original Discord log file except for whatever Discord would keep on their servers. Destiny, how did she not give plaintiff the evidence? Because she doesn't have the evidence. Because it's a fucking lie. You can tell because Abby freaked the fuck out when her name was made public in the filings because they fucked up when they tried to redact her name. They redacted her full name in the first line, but then in the second one, they said her Discord name is Abby MC. And so she started freaking out because she's like, oh shit, I didn't know my identity would ever be public about this. They fucked her really hard is what happened. Because they're either incompetent, stupid, or just don't give a fuck and it's all a meme. But I'll also assert, there's also, I would say in my opinion, there's also a massive conflict of interest that I think that the plaintiff's counsel should have to contend with, and that originally, based on messages that Abby's leaked to other people and messages to me, it looked like Abby might have wanted to settle something with me privately, maybe, possibly, to remove her from all of this. I don't know 100%. That's definitely what it read like. However, her lawyers that are representing her, or they were for a little bit, were the same lawyers as Pixie's lawyers. That's a massive conflict of interest. There is no world where Pixie's lawyers are going to let Abby settle anything with me when Abby is the star witness on Pixie's case. So they're fucking Abby over hardcore by precluding her from entering into any conversation with me but they, at one point, they claimed to represent her. Now they claim that they no longer represent her. I don't know what the fuck that means or what that was, but that is a massive conflict of interest that severely, I would say, could severely fuck over Abby's whatever she wants. So. If the law about sharing videos and stuff didn't exist in Florida, we need it, then why can't the case just get thrown out? Well, that's what we're fighting over. But they're lying on all of their evidence on everything. So we have to like contend with that basically. That's what all these back and forths are for basically. Defendant's failure to serve Abby MC is not relevant. Defendant next argues that Abby MC evidence should be disregarded because he's been unable to serve her with a subpoena. This contention fails for several reasons. First, defendant offers no evidence of any effort to locate or serve Abby MC. What a piece of shit. Joan wrote this. I know she did. What do you mean? We've asked you for her address. Like, you can ask. We've got like records on our own of like the service provider trying to hit her addresses and everything to serve her with a subpoena. Like, what do you mean? Like, do you think we're just lying about this? Second, he provides no basis to claim that plaintiff's counsel represents Abby MC for purposes of service. Now, that's a tricky line. They did represent her because they sent us a demand letter initially, but then they stopped representing her. I don't know what that was about, but okay. To the contrary, undersigned counsel expressly advised Mr. Brettler that they did not represent Abby MC for purposes of the subpoena, that they were not authorized to accept service on her behalf, and that they had never instructed her to evade service. Why would you not facilitate this? Hello? Why would you not facilitate us deposing you know what's going to have to happen eventually. This is your star witness. Why would you keep assisting your star witness of hiding or evading subpoena or deposition? Like, what? This is your only person that you have here. What's the point of this? Again, it's because they know it's all bullshit. They know they've lost. They're just trying to kick it out as much as possible. Third, counsel recently obtained Abby MC's last known address and promptly provided it to Mr. Brettler upon receipt. Wow, thank you for the last known address. That also is no response. Thank you so much for that. Defendant's position is further undermined by his own conduct. His initial disclosures identified 11 individuals likely to have discoverable information, including Rose, yet he has not produced contact information for any of them. Plaintiff was forced to hire a private investigator to locate Rose. So I don't know if you're allowed to make initial disclosures public. I thought that was private information. Now, they accidentally published theirs publicly. They fucked their filing up. Go figure. However, in my initial disclosures, all I have to do is provide all the information I know about the person. If I don't know a person's phone number, address, real name, I can't invent that information for you. I'm just providing you, in good faith, people that I think are likely to have discoverable information. I didn't produce contact information for a lot of these people because I don't know their contact information. Also, I will say though, on that list of people, all of them are also probably closer friends with Pixie than me at this point, and she knows all of their information. So like, who are you having a hard time covering on this list? Who can you not get a hold of? Like, this is just a red herring. It's bullshit. Plaintiff was forced to hire a private investigator to locate Rose. You weren't. You just copied the information off Kiwi Farms like your expert witness did. Finally, the authority defendant cites is inopposite as it concerns expert witness disclosures rather than lay witnesses. Conclusion: defendant cannot use Rule 12b1 to litigate the merits of plaintiff's Cardi claim because jurisdiction and the merits are inseparable, and because plaintiff's claim is neither immaterial nor frivolous. Dismissal is foreclosed. At this stage, where discovery is ongoing, material factual disputes abound. The motion must be denied either outright or at a Rule 56. Oh god, that's there. So again, I don't know what these filings normally look like. It feels to me like if subject matter jurisdiction was on the table, and there's a big question that the judge himself has pointed out that subject matter jurisdiction hasn't been established. It's crazy to me that in their response to our motion to dismiss, that they don't provide a single piece of evidence strengthening their subject matter jurisdiction claim. That's crazy to me. It's all just trying to nitpick at my stuff. This is your chance to present evidence that the judge should basically accept without analysis. He should, because it's a motion, it's a 12b1, it's a motion to dismiss. He should read basically everything that you put in as true. So I don't know. That's crazy to me, but okay. Sort of chat thread between this is probably what was everyone Jesus shit, basically. You keep saying that, but it's not true for a 12b6. Wait, why? Wait, is that the summary? I'm sorry, is that the oh, that's a motion to dismiss for failure to state a claim. Wait. Hold on. But the failure to state a claim relies on him discrediting some evidence. 12b1 doesn't require judge assumes complaint is true. Oh, wait, you're saying 12b1 doesn't require it? Wait, are you sure? I would have to go back and reread. But I'm pretty sure they basically have to read your motion. I'll link it. I don't know where it is. Which, give me a paragraph. I'm not rereading my whole... Wait, that's a response. Wait, I don't even know where this would be. Listen, if you want to give me a paragraph, go to legal standard. Control F, legal standard. 12b1 authorizes dismissal with a court like subject matter jurisdiction. Jurisdiction may be facial or factual. A facial attack on subject matter jurisdiction accepts the allegations. Oh, maybe I didn't read this right. Maybe I skipped over because it's legal shit. A factual attack by contrast challenges the existence of subject matter jurisdiction in fact, irrespective of the pleadings, and permits the court to weigh the evidence outside the complaint, including affidavits and testimony. Critically, in a factual attack on subject matter jurisdiction, no presumptive truthfulness of testimony. The court may resolve disputed facts, holding that a district court may consider matters outside the pleadings when resolving a factual attack. It's a proper. Isn't this for a? Oh, and that dismissal not. Oh no, I did. I don't think it's guaranteed that he has to. He has to read this. Like I think that the. I think that whether or not the judge considers factual stuff when it comes to a motion to dismiss is like up to the judge himself. Because generally, I think generally a 12b1 usually comes at the pleading stage. It's like a response to the complaint, in which case there isn't much to read in terms of factual stuff, right? Because no discovery has happened yet. It's up to the judge how much he wants to read. Because this is just making the argument that they could weigh factual stuff, but they don't necessarily have to yet. It's up to the judge, I think, right? But regardless, I mean, if he does, all it does is it helps. All it does is it helps me, right? It is discretionary, but generally just going to do everything they can to not make a factual determination. Yeah, sure. Unless it's like super clear. But again, us being so deep into this case and the fact that, like, I feel like all of the things that they have discretion on, I feel like they weigh pretty heavily against the plaintiff, because we've gone this far in and they've submitted no evidence. Look at our docket, man. Oh, look at this sweet docket. Almost 150 items. 8 months into a court case. What the fuck? Yeah, busy that docket up. Okay. That was their response. Jesus Christ. Sorry, okay. That was a lot. Okay. The rest of these will be quicker. Oh my God. I almost cried when I read these. Finally got more guidance from the judge. Okay. These are my one ruling. I said they were two big rulings. I'll say one probably small ruling. Okay. And then the big good one. Oh. Every time I read anything with this guy, I'm so scared that like the tech stuff is just going to be too hard for them to parse, but the judge seems like incredibly tech literate. But even I've said this before, people think judges are stupid, but even in like that Kyle Rittenhouse case, I brought this up a lot, but like even saying people were making fun of the judge for that pixels or whatever argument or whatever. And if you're actually watching the court case, what that judge was saying was actually 100% digitally sound. The idea that the way a video is encrypted, or how you're looking at things like the pixels could be transposed, or that there's some information that's being filled in by any algorithm that's encoding a video, it was actually, it wasn't just true. It was a very like digitally sound, intelligent point that the judge was making that a lot of like laymen might miss. Because people assume that when you're looking at a video, all of the information on the video comports with reality. But that's not true when you're talking about digital compression algorithms. Like sometimes there is an algorithm that is guessing sometimes what's in, a particular place in a video. Now, 99.99% of the time, this doesn't matter because it's like guessing stuff like the color or the shadowing or the lighting or whatever. But in the Kyle Rittenhouse thing, basically, in my opinion, almost all of that case could have come down to, this one video where Kyle Rittenhouse is shown, and it's like 20 pixels of a guy in the distance. Fuck, I'm not gonna be able to find the video. But one interpretation of those pixels could be him like lowering a gun and threatening it, and then taking it up and chasing something, or it could just be him like walking. It was a drone video by the FBI. Do you have a link to it? Destiny was right there. Right where? Which one? The white video. This one? This one? Oh, it was the drone video. My
shot. Court. Everything of trial. Every mention about the Rittenhouse running. What they did is they zoomed in on it. Take a look there. You see Kyle Rittenhouse running. Rosenbaum behind him, and there's the shot.
No, it wasn't this video.
Barrel of the weapon.
Yes. Forward. Missed.
He was down the street on a video. It was one where he was further off in the distance. It's not this video. Classic.
Kyle, what the fuck?
Stop.
We've talked to Mr. Rittenhouse, and I'm
charging at Rittenhouse when he opened fire. The putting Joe executed Rosen pushed with hope
had the video not declared
the defense, but may have been
the quality.
The prosecution said the high-def version.
I think it might have been this, because you can see him like it's like really far in the background.
Somehow.
On Monday, the defense cited the drone video as T, claiming he has pleaded consent here.
Oh wait, was it this one?
Night of protests last year in
I feel like it was him where he was standing down the street or something.
Wisconsin.
But it was like this is like a matter of like dozens or less of pixels, like determining like what the action was like prior, because they were trying to make the claim that like prior to him, I think it was the claim was like prior to running, he was like threatening somebody with a firearm, and it was like, was it this? Hold on. I thought it was, yeah, I feel like it was something, I feel like it was related to this, but I don't know, whatever. Okay, regardless, not important. Okay, I'll be back when I grab Red Bull, and then we're gonna read. I got 2 big good rulings from the judge on this. And then we're almost done with this, sorry. It's just my life now, okay, so hold on. Here's a zoomed in part, I think, that was in question. It's hard to say because of the blinding lights. Warning, dude gets dead. If you don't want to see dude get dead, turn back now. Oh wait, this looks correct.
So the orders you hear about yelling no cameras, them is white boys. Yeah, that's Antifa, man.
Okay, yeah, it was this.
No cameras.
Oh fuck, I remember, hold on. It has to do with...
So the orders you hear about yelling no cameras, them is white boys.
I'm not gonna be able to see it without the plaintiff, the prosecution pointing it out. But there's like a part here where it's Rittenhouse standing, and it is literally like a couple dozen pixels, like whether he raised his gun and threatened somebody before running away or not. But like, you can't reliably tell from the footage. And there was a big fight over whether they could even have it as evidence or not. I don't remember what they ultimately ruled on that. I think they did allow that to be shown to the jury, didn't they? I don't remember. But okay. God, Judge, Torres. I can't roll my R's, okay? Order on plaintiff's motion for entry of order to compel Lawkill LLC to remove videos. This matters before the court on Plaintiff Jane Doe's motion for entry of agreed order to compel Lawkill LLC to remove videos. The defendant timely responded, to which plaintiff timely replied. Plaintiff also filed on the docket a stipulation between plaintiff and non-party Lawkill LLC regarding limited submission to jurisdiction. Accordingly, plaintiff's motion is ripe for disposition. Ripe meaning now is an appropriate time, I think, to rule on it, right? After careful review of the motion, response, reply, relevant authority, and for the reasons discussed below, plaintiff's motion is denied. Background. This case stems from what plaintiff alleges is defendant's wrongful dissemination of a video of a sexual nature involving both Ms. Doe and Mr. Bunnell. Defendant, for his part, alleges that the situation was more complex and that both plaintiff and defendant repeatedly shared similar materials involving third parties with each other, and that practice in effect extended to other individuals. It was then one of those other individuals, Rose, whose Discord account was allegedly hacked, which resulted in the leak of several videos of a sexual nature involving defendant, including the video. The video, in the form of what appears from plaintiff's proposed order to be several iterations of uploads, is now on a multiplicity of websites hosting content of a sexual nature, among them Kiwi Farms. While plaintiff alleges that defendant's conduct caused the video to end up on Kiwi Farms and other sites, the parties appear to agree the defendant did not himself upload the video to Kiwi Farms. So this is kind of like minor stuff. So one of the really nice things about getting rulings from a judge on particular things is based on what they write in the rulings, you can kind of see like what direction the judge is leaning or like what's going on in the judge's mind. It's kind of like when we're listening to oral arguments for Supreme Court rulings, based on the questions the judges ask, we get a pretty good feel of like, okay, well, where is this justice leaning in terms of this based on the question, right? So, like for our motion to dismiss, my understanding is it's like the likelihood of succeeding is, I believe it's low, although the guy in chat is saying that they can consider the evidence, but like how the judge rules on the motion to dismiss gives us a lot of guidance for the motion for summary judgment, which would be really good, right? So, okay. So, now, I know that Kiwi Farms and every other, retard internet lawyer is trying to say, well, it doesn't matter who ultimately uploaded it. The only thing that matters is who initially, who leaked it or who sent it without permission, whatever. That's not true, actually. Like, proximate harm and foreseeability are actually incredibly important in tort when it comes to figuring out who's, liable or responsible for a particular thing. And one of the really difficult arguments that plaintiff is going to have is establishing why I would be, if assuming, I lost on the merits of all of this and assuming they won in front of a jury on this, when it comes time to figuring out damages, you would have to show like, okay, well, what was the foreseeability that if the defendant sent some video to some person, that it would then be leaked onto the internet? Because you have to be very careful in making that argument because you can undermine the plaintiff's entire argument herself if you start saying, well, if you sent a video, and they did make this argument in the hearing, which was funny because the judge did call it out, which was also funny, but I can't go over the transcript of the hearing yet. But there was this saying, well, anytime you send a video to anybody on the internet, of course, there's a chance it could be leaked. And it's like, okay, well, didn't the plaintiff do this? Doesn't that kind of undermine your whole argument? Like, it's a slam dunk case against Solo. It's a slam dunk case, maybe even against the Rose person, but against me, it becomes a much more difficult area to argue because, like, the foreseeability of any of this is obviously, well, we know it's like very low. Like, obviously, it happened years later. The idea that anybody would foresee this is not high. Otherwise, there's probably a whole bunch of behavior that would have been differently. Yes, but anyway. Okay. But anyway, all that to say that it's nice that the judge agrees that this is an important fact to lay out. I think that's good guidance. I feel like it's good, but okay. And then he's just quoting from our prior things, I think. All right. The video, as originally uploaded, remained live on Kiwi Farms from the time when it was first uploaded until just after this lawsuit was filed. At that time, Kiwi Farms intervened to put the videos behind a registration barrier, citing concerns about the impact on certain individuals involved. But re-uploads of the video remain on Kiwi Farms, and plaintiff now asks the court to compel Kiwi Farms to remove all those currently identified. Plaintiff has garnered some cooperation from Kiwi Farms in this endeavor in the form of a limited submission to jurisdiction and reasonable understanding of what the site is to do, were we to enter the agreed proposed order. Still, Kiwi Farms apparently will not do so unless ordered. Defendant, for his part, contends that not only would such an order be futile because individuals can simply re-upload the video anew, but also the plaintiff's request is an injunction and a motion to compel clothing and is thus impermissible. So, oh, fuck. This is something that I brought up in my hearing. I'm not allowed to read from it because it's still sealed. But when Pixie's lawyers were trying to cross-examine me and they were asking me about this, like, oh, well, why would you oppose this or whatever? These are my two arguments: is that a motion, a court order to remove a video is not a good remedy because it doesn't enjoin them from future behavior. It's just a one-time deletion of a video. Somebody else can re-upload it, number one. And number two, you're trying to compel somebody who's non-party to the case. You can't do that. They have no tie-in to this case. Why would you imagine you could issue a court order or an injunction at all? You definitely can't enjoin a party that's not part of a case. It doesn't make any sense. It's totally inappropriate. But what does it mean to compel clothing here? Well, because Pixie doesn't really want like 4 links to a video removed. What she really wants is for all of her inappropriate material to not be posted ever on Kiwi Farms. That's an injunction. You're enjoining a party from future behavior. You're saying you cannot do this anymore as declared by this court. That's an injunction. And this cute, like, oh, I just want them to take it on a link. That's not really what you're asking. It's not really what you want. And to do that to a non-party that isn't representing itself or allowed to answer any of your motions, it doesn't make any sense. It's ridiculous. Okay. Analysis. We begin at the end, which is to say by looking at what exactly plaintiff is asking the court to order. The agreed proposed order, to which plaintiff repeatedly refers to in her briefing, seeks the following. LawCal LLC is hereby ordered to permanently remove from its website Kiwi Farms the following URLs which contain or link to a non-consensual image, intimate image / video of plaintiff. One thing that I really fucking hate that is ultra super fucking disgusting, and I'm going to talk about it a lot more when this lawsuit is finished, is they are very, very, very careful when referring to any of my revenge porn that was hosted on Kiwi Farms to never, ever mention that I was the victim of any of these leaks. And it is always solo talking about her as the victim. They're very careful of that. So it's never linked to non-consensual intimate images or videos or non-consensual intimate images or videos of the parties to this case or of plaintiff and defendant. It's only to her because they still have this argument in the back of their mind that I leaked it all intentionally or whatever bullshit. I think it's super gross, but you know, it's come up in past things and we'll see in the future. The proposed order then proceeds to list a number of URLs that all begin with https kiwifarms.net/threads. Because it oh my God, every time this judge, talks about anything related to tech or anything, I'm just like so relieved. Okay. Oh my God. Because it bears on what plaintiff ultimately seeks, it merits noting that plaintiff's proposed order reflects a misunderstanding about how URLs function. There is no permanent removal of a URL from a website in the manner the proposed order seems to suggest. A URL is basically a pathway to get somewhere on a given site. Here, kiwifarms.net is the domain, the google.com, to use a more common example. Then trailing that /threads is a pathway within the site. For each of the URLs plaintiff lists, what follows /threads appears to be a unique identifier, each belonging to, and thus routing to, an iteration of the video on the Kiwi Farms site. In other words, the URLs plaintiff lists are nothing more than functions of how the site directs to, stores, and receives information. A given URL itself cannot be permanently removed in the sense that she suggests. You could, for instance, reroute anyone trying to access a specific page back to the site's homepage or to a 404 not found page. You could also delete information from a database so that a given resource is no longer available, but in any event, the desired manipulation would have to occur by way of the underlying mechanics of Kiwi Farms, a change that may or may not be reflected as contemplated in the URL. Plaintiff's desired result is, by its text, misplaced. So what they're saying is, like, if I were to say, hey, you have www.destiny.gg/porn video, can you remove that link? That's bullshit. That's not really what you need to be asking. What you want to ask is, I need you to remove that media from your servers, or at the very least, make that media permanently, publicly inaccessible. That's what you're really asking. To remove a URL, is okay, fine, I'll rehost it on a different URL. It doesn't make any sense as formed in the text, you know? Additionally, and to the court's knowledge, while both parties separately allege that the video was uploaded to Kiwi Farms without either of their consent, neither party is alleging that the subject of the video itself or the recording thereof was without consent. Without further context, the statement that the following URLs contain or link to a non-consensual intimate image/video of plaintiff could well suggest different allegations than those in the pleadings. I love that the judge is like cognizant of the fucking horrible language games that Pixie keeps playing in all of these stupid fucking motions to make everything sound so much more loaded than it actually is. I love that he is aware of this. Thank God. For this and the reasons enumerated above, plaintiff needs to be more specific with the relief she requests of this court. Despite asking the court time and again to refer specifically to the agreed proposed order as the crux of the relief requested, this order reads as little more than an afterthought. And even beyond the proposed order, plaintiff's motion concludes in a similar fashion. So I don't know how judges ordinarily phrase things, I guess. So I can't tell like what's like, I don't want to say like passive aggressive, but like this feels to me a little brutal, right? Like you're fashioning an order that supposedly has to do with something that's incredibly important to plaintiff, but it reads as little more than an afterthought. I feel like you're not putting a lot of effort into what relief you're requesting from the court. Remember, courts are here ultimately to do just that. For tort is to provide relief, right? You feel like you've been wronged by a party, we're here to make you whole again. So the type of relief you request is pretty important. But in any event, wait, did we already go through footnote 2? Or when did that come up? Oh. Plaintiff does later characterize Kiwi Farms' supposed understanding of the proposed order as including that it will remove the content hosted at the enumerated URLs from the Kiwi Farms website. While that is more specific, plaintiff nonetheless consistently points back to her agreed proposed order that was workshopped with Kiwi Farms as the ultimate relief being sought. Okay. But in any event, plaintiff is ultimately asking the court to force Kiwi Farms to take some kind of action to either delete or otherwise make inaccessible any identified iterations of the video as enumerated in her proposed order. Plaintiff fashions this request as one for entry of agreed order to compel Lolcal LLC to remove videos, a quasi-motion to compel. We will proceed to analyze it as such. Importantly, Kiwi Farms is not a party to this action. This is one of the things I keep saying over and over again is one of the tricks that they're trying to play is they keep trying to hold me accountable for the actions of Solo or of Rose or of Kiwi Farms, but they did not name them in this lawsuit. These people are not named as defendants. So one of the big issues is assuming that they survive this motion to dismiss, assuming they survive motion for summary judgment, assuming we go all the way to trial, assuming they get a conviction, not a conviction, I don't think you would say, assuming that they win and they get the jury to, I don't know what you would call it in a civil case, the jury to agree that I have violated something. When we go to talk damages, they want to keep saying that like all this stuff posted on Kiwi Farms is my fault, all this, well, but you didn't name any of them. So they want to keep bringing in all the damage that resulted from this, but they refuse to name a lot of the parties that were like directly implicated or involved, you know? Importantly, Kiwi Farms is not a party to this action. No limited submission to jurisdiction changes that fact. With good reason, the power of federal courts over such non-parties is limited, which makes sense, right? Imagine if all of a sudden you got an order from a court saying you're no longer allowed to do this. And it's like, excuse me, I didn't even know I was part of this court case. You can't tell me. The court can't enjoin me from some future behavior. I didn't even get to represent anything I'm saying. Wait, what the fuck? How do I even challenge this? I don't even have standing to say anything. It's not even my court case, you know? It makes sense, right? You can't enjoin people that aren't parties to court cases, you know? You can compel them for things, though, like subpoena or some kind of like documents, obviously as part of discovery. But Federal Rules of Civil Procedure 37 and 45 both regard situations where non-parties can be compelled to participate in litigation. That's what this is. If the person is a non-party, production of documents can be compelled only by a subpoena. Deuces tecum. How do you pronounce this? Hold on. I need to. You shall bring with you. It's a phrase. Subpoena is a court order that compels a person. You shall bring with you. Hold on.
Res ipsa loquitur, subpoena ducis tecum.
Ducis tecum. Good one. Purpose of Rule 37 is to provide the mechanism by which Rule 26 and 36 can be made effective. It is of limited application when applied to non-parties. It can only be used to order a non-party to answer written and oral questions under Rules 30 and 31. It has no application to a non-party's refusal to produce documents. Rule 37, moreover, authorizes the basic motion for enforcing discovery obligations, under which conditions, including failures under various other discovery-related federal rules, including failures under various other... Okay. And okay, so it's just saying like how you would do subpoenas, what these motions are for. Subpoenas to compel non-parties to produce documents related to a lawsuit. Okay. But plaintiff is not seeking a deposition or information. Instead, she is asking us to issue an order forcing a non-party to take an action as to its own website, its own business. By the necessity of what Kiwi Farms would have to do because of any such order, i.e., in some manner removing or hiding the identified iterations of the video, we can only construe plaintiff's motion as asking this court to issue an injunction requiring Kiwi Farms to act. And that we cannot do. Courts of equity have long observed the general rule that a court may not enter an injunction against a person who has not been made a party to the case before it. I've been screaming this for so long. I'm so glad to have this because fucking the internet dipshit lawyers and all these other retards have been commenting on my case with supposedly have law degrees from whatever bullshit school keeps saying that like, oh no, maybe you can do it. No, you can't issue an injunction against a non-party to a case. Like just, if you just think about it, even in layman's terms, it just is obviously retarded, right? Oh, I'm going to go sue John and as part of my court case against John, I'm going to get major injunctions against Fred who has nothing to, like this is just so stupid. It's obviously stupid. But thus, it is axiomatic that courts may only enjoin parties before the court. To that end, Federal Rule of Civil Procedure 65 is explicit as to persons who may be bound by an injunction. A, the parties. B, the parties, officers, agents, servants, employees, and attorneys. And C, other persons. Blah, blah, blah. Kiwi Farms is neither a party, nor an officer, agent, servant, employee, or attorney of either plaintiff or defendant. Kiwi Farms is also not in active concert or participation with either plaintiff or defendant. I'm glad that the judge said this. As for defendant, he contends that a number of his communications and sexually explicit videos were published to a website called Kiwi Farms, and that he does not know who leaked and unlawfully published his content online. Thank you for saying this. And as for plaintiff, notwithstanding any halfway cooperation from Kiwi Farms on a proposed order, the very fact that plaintiff is moving to force Kiwi Farms to, in whatever manner, revoke public access to the video is inherently adversarial, as in you're compelling them to do something they might not otherwise want to do, right? So they should probably get a response to this, you know? Correct, Jen. The correct procedure was to add Kiwi Farms as a defendant, but they don't want to do that because then Kiwi Farms would be assessed with the most fault. That is correct. Because one, Pixie probably wants to avoid the harassment, and two, she doesn't think she can get any money out of Kiwi Farms. She does think she can get money out of me, and she wants to tank my reputation. She doesn't care about Kiwi Farms' reputation. So why would she bother naming them as a defendant when the only goal is like memes and frolicking and fun and adventure and whimsy? Thus, non-party Kiwi Farms is beyond the reach of this court's injunctive power, at least based on the nature of the pending action. Accordingly, plaintiff's motion to compel is cooked. Conclusion, for the court is hereby ordered. Plaintiff's motion for an okay, denied. Okay, so that was like decent. I'm glad that that was filed. Okay, I went over this, that Jesus himself retracted some of his expert witness testimony because it was also cooked. All right, this was my big ruling that I'm glad about. Okay, so as a quick thing, courts are generally here to make you whole after you've been damaged. In exceptional cases, you can request something called a TRO, which is a temporary restraining order. TROs are things that are heard ex parte or ex parte, meaning only one side has to go before the judge and say, listen, I am going to be irreparably harmed. Irreparable harm is really bad. A court doesn't want somebody to be irreparably harmed because if you're irreparably harmed, the court can't do anything to help you. They can't make you whole again, right? You're literally saying it's irreparable by the language, right? It's irreparable. So a TRO is saying, listen, judge, if you don't stop this, okay, I'm going to be so fucked. There's no point in me even bringing this case before the court. I'm fucked, right? So maybe like in a case, I don't know if this would be criminal, but like I don't like to use this example. Like, let's say you're like unplugging somebody from life support, right? Maybe you get like a temporary restraining order, like, hey, we're arguing about whether or not the person has the right to unplug this guy from life support. You have to stop this right now, because if they're allowed to, there's literally no point in having this court case because they're going to be dead and you can't do anything to help that, right? So this would be right. That's what a temporary restraining order is for. Now, a temporary restraining order, that's an extraordinary measure that the court has to take. I believe for a TRO, you have to show a likelihood to succeed on the merits, and you have to show irreparable harm. And you have to show both of these things. I believe you have to show both of these things. They tried to file their TRO. However, they filed their TRO like a month or two after their case was filed, which already is highly sus, because if this is so important, why the fuck you usually, like, for instance, when we've been following like the immigration stuff, I'm pretty sure like the TRO is filed the same day, right? Remember, this is like, I'm fucked if this happens. So like you file a case and the TRO is like right the fuck after, like, I need this to stop or I will be irreparably harmed. They waited a few months after. They got blown up by the main judge for waiting. They had no excuse besides, they said one of them had cancer and was going to Texas for treatment, and they said one of them had pneumonia and couldn't file it. It's like, what? This is a joke. But okay. But, oh, okay, sorry. That's a TRO. A preliminary injunction is similar, except a preliminary injunction comes a little bit after a TRO. Let's say a TRO gets denied, but the preliminary injunction is not ex parte, meaning only one party gets to have a say. The preliminary injunction has the defense come in and give their arguments. For a preliminary injunction to succeed, there are 4 different points that you need to succeed on for a preliminary injunction to be granted. However, the defense gets a say as well, so they can argue before it, and then they'll go through this and this. Okay, so this is a ruling on the preliminary injunction. Funnily enough, again, we're 8 months into this court case, but okay. All right. Here we go. The matter is before the court on plaintiff Jane Doe's motion for preliminary injunction. Defendant responded timely, to which plaintiff timely replied. An evidentiary hearing was held on the motion. Accordingly, this hearing is the one with the sealed transcript so far, waiting for the judge to rule on it, but okay. Accordingly, plaintiff's motion is ripe for disposition. After careful review of the motion, response, reply, relevant authority, and for the reasons discussed below, plaintiff's motion is denied. So if I'm being totally honest, my kind of hope or expectation was that it would be like denied in part, and maybe the judge would just grant a few things to the plaintiff here in terms of publishing stuff, maybe, because like there were a couple requests, like maybe they will apply like one part. So the fact it was fully denied, I think is I think that was good. I like that, but obviously, but okay. The case stems from what plaintiff alleges is defendant's wrongful dissemination of a video of a sexual nature involving both Ms. Doe and Mr. Bonnell. Both plaintiff and defendant are live streamers. Accordingly, plaintiff and defendant met online on or before late 2019. Their online friendship. Eventually, this is just going over the factual background. In either April or October of 2022. So he references this, our dispute of the date. The parties' arguments over whether the video was sent to Rose in April 2022 or October 22 are the basis for the dispute regarding the court's subject matter jurisdiction over this case. Defendant alleges that the date on the chat is displayed as it would be in Europe, with the month and the day reversed compared to how it would appear in the United States, and thus plaintiff misunderstood the chat as having taken place in October of 2022. Keep in mind on closer examination, when the judge is making a formal ruling here on the preliminary injunction, we don't see the same... like, oh, it's murky. Who knows what's going on? It's impossible to tell, right? But, you know, I don't think he's like hardcore even still diving into it. But defendant alleges that since that date, he has not shared or otherwise transmitted the video to any other third party and will not do so. Emphasis on original. Plaintiff alleges that defendant has shared the video with at least one other individual beyond Rose, Abby MC. Plaintiff further alleges that defendant's practice of hosting sexually explicit material on a Google Drive and sharing a link or links to that Google Drive constitutes ongoing dissemination. Destiny, not the hearing in June. This is the April hearing they're referring to. Oh, is it? Oh, then it's the one before that. Sorry. Wait, are you sure? DE 49. No, after May? No, I think this was when we went to court, because it was after that, right? When I had my suit and everything. But it doesn't matter that much. But okay, all right. Accordingly, plaintiff. Okay, where were we? In any event, the video was uploaded to the website Kiwi Farms on November 29, 2024. The video was uploaded under the screen name Solitani Leaks. Both parties allege that they did not consent to the uploading of the video onto Kiwi Farms. Defendant, for his part, alleges that he was the victim of revenge pornography and suspects it was someone with access to Rosa's Discord chats. The video was one among many involving defendant that were uploaded to Kiwi Farms. Further, the video did not remain only on Kiwi Farms and has been found on other sites that similarly host material of a sexual nature. Plaintiff and defendant both alleged that they made overtures to have the video removed from various sites. On January 22nd, 2025, plaintiff's counsel sent defendant a letter entitled Demand for Preservation of Evidence in the Matter of Jane Doe versus Stephen Bonnell. The letter advised defendant in writing of the pendency of the present action and included the following. You're hereby advised of your legal obligation to preserve, maintain, prevent spoliation of, and not destroy evidence which in any way relates to this matter. Plaintiff then filed this lawsuit on February 18th, 2025, and on April 3rd, 2025, plaintiff filed the motion presently before us, which requests a TRO and preliminary injunction for the following. So they were asking, this is what they were asking for in their preliminary injunction against me, right? So before any court case has gone through, this is something that they were asking of me. So they wanted to stop me and enjoin defendant Stephen Bonnell from further sharing, distributing, or publishing the intimate images / videos and or intimate information of plaintiff. And 2, compel Bonnell, me, to remove all publications of the video and all messages between him and plaintiff from all forms of public media he controls either directly or indirectly. And then 3, order defendant to direct third parties in writing to remove all published intimate images / videos of plaintiff and any intimate information regarding plaintiff under their control. And 4, order defendant to retrieve the messages he has deleted, to cease and desist from destroying evidence, and to preserve all discoverable information relevant to this action from his phones, computers, tablets, online, blah, blah, blah. Okay. So like, I guess in my mind, I was wondering or worried, like this is all, like, because I'm trying not to get gaslit by the horrible fucking Kiwi Farms lawyers or the legal mindset dipshit online. So I'm like, maybe the judge could grant like 4 just to say, is like, well, yeah, obviously you shouldn't delete evidence. But like in my mind, I'm like, well, I don't know why a TRO is an improper, or a preliminary injunction. These are improper vehicles for this type of behavior. I'm already not supposed to delete anything. Why would you need a preliminary injunction to tell me not to do something that I'm already not? That's in my mind. So I was like, well, fuck, maybe the judge will grant some of it because I just do. I don't know. So this is why I'm glad that the whole thing was shut down. And keep in mind, as we go through these 4 elements, element meaning it's required to be met for some legal thing, you only have to lose on one in order to have your preliminary injunction fail, I think so. Okay. At a subsequent hearing in April 4th, oh, so that thing was for the first hearing, okay. The first hearing I wasn't at, the subsequent one was the one I was at. At a subsequent hearing on April 4th, 2025, Judge Becerra denied plaintiff's request, or I think, or no, maybe this was the second hearing, this wasn't the one either. I don't know, whatever, it doesn't matter. Denied plaintiff's request, no, because this wasn't the one I was at. Denied plaintiff's request for a TRO and subsequently referred the remainder of plaintiff's motion for preliminary injunction to the undersigned for disposition. The court held an evidentiary hearing on the motion to address the disputed issues of fact presented by the briefing on the motion. So, a lot of the fake Kiwi Farms lawyers and everything keep saying things like, oh, well, Abby didn't have to actually go to that preliminary injunction hearing. She wasn't required to, so it's stupid that they keep bringing it up. Well, a lot of the preliminary injunction has to do with like, am I deleting evidence? Like, am I still sharing videos? Like, if Abby shows up at that preliminary injunction hearing and she testifies and she provides some evidence that like, oh, look, I'm still sharing videos, then the plaintiff's argument becomes much, much, much stronger. That some sort of preliminary injunction is needed to enjoin me from an ongoing bad behavior that would possibly irreparably harm the plaintiff, right? But they didn't provide her. In fact, they only added her onto their, I think the preliminary injunction request, they only added her on at like the day before the fucking hearing. It was a joke. But applicable principles and law. The basis of injunctive relief in the federal courts has always been irreparable harm and inadequacy of legal remedies. Sampson v. Murray. To obtain a preliminary injunction, a movant, so that's the person who files for a motion, okay? A movant must demonstrate the following. 1, a substantial likelihood of success on the merits of the underlying case. So meaning that like you're likely to win the case on the facts, right? 2, the movement will suffer irreparable harm in the absence of an injunction. Now, irreparable harm is important. It can't just be harm. It has to be irreparable harm because a court can make you whole again for harm, oftentimes through monetary compensation, right? That's the whole reason why you sue somebody is to make money, is to get money out of somebody. Irreparable harm would go back to like the There might be some things some things I think are considered by default like irreparable harm. So like, I'm not even gonna have examples, but there are some things where it's like, obviously the court can't make you whole. Maybe like the first leak of like a video or something would be like, okay, well, like if you're gonna do this first leak, like I'm fucked. Like if this person publishes this, there's no way the court can make me whole after this, But irreparable harm is key there. It's not just harm, it is irreparable harm, okay? 3, the harm suffered by the movement in the absence of an injunction would exceed the harm suffered by the opposing party if the injunction is issued. So that means that like, if you're saying that there's going to be some harm here and you're going to force the opposing party, force the defense to take some action against you, you got to show that your harm would be worse than the harm that they would incur by stopping to do such a thing, right? Because it could be like, let's say, for instance, that I host a DGG chat and she's saying things like, I need you to take DGG chat down completely because they are making fun of me or something and that's irreparably harming me. They might share a video in there, right? Well, my response would be like, you're telling me to take down basically half my business. That's a huge harm for me. There's no way you can do this with a preliminary injunction. Maybe at the end of a court case, sure, but not in the preliminary stages. That's crazy. This is such a burden on me, And then 4, an injunction would not disserve the public interest. I don't know how this applies here, or I don't know exactly what this means, but something probably not related to me. I don't know. Maybe it'll come up later. Okay. For a preliminary injunction to succeed, okay, all 4 of these things have to be met. All right. So if you fail even one of them, then your preliminary injunction fails. In the 11th Circuit, a preliminary injunction is an extraordinary and drastic remedy not to be granted unless the movement clearly established the burden of persuasion as to the 4 requisites. Because a preliminary injunction is quoting from another case, extraordinary and drastic remedy, its grant is the exception rather than the rule, and plaintiff must clearly carry the burden of persuasion. However, if the movement is unable to establish a likelihood of success on the merits, a court need not consider the remaining conditions prerequisite to injunctive relief. So this is talking about the first element, and if you can't even demonstrate the first element, we don't have to consider the rest, right? Hold on. Jesus. The goal of a preliminary injunction is to prevent irreparable harm and to preserve the district court's power to render a meaningful decision after a trial on the merits. Remember, the court's goal is to make you whole again. And if there's going to be irreparable harm, well, then there's no point in going to court. So you want to preserve the court's power to render a meaningful decision to be able to make you whole, right? The most compelling reason in favor of granting a preliminary injunction is the need to prevent the judicial process from being rendered futile by defendant's action or refusal to act, right? Like if you can fuck something up so hard during the court case, then who cares how the court rules at the end, right? So they want to preserve the power of the court to do something good, Preliminary injunctions are issued when drastic relief is necessary to preserve the status quo. Status quo is I think that comes up a lot for that. Somebody said, when's this going to be over with? Drama is boring to me personally. I agree, but my entire career and every single thing in my life is basically paralyzed till this court case ends. So here we are. As annoying as it is for you, imagine how annoying it is for me. When injunction does more than preserve the status quo, however, an even stronger showing is required. A mandatory injunction, especially the preliminary stages of a proceeding, should not be granted except in rare instances in which the facts and law are clearly in favor of the moving party. Mandatory injunctions are rarely issued, and interlocutory mandatory injunctions are even more rarely issued in either except upon the clearest equitable grounds. 3, analysis. Okay, so we're just going over some of this. Okay. First, a party requesting a preliminary injunction must generally show reasonable diligence. Thus, a delay in seeking a preliminary injunction of even only a few months, though not necessarily fatal, militates against the finding of irreparable harm. Okay, so remember what I said at the beginning, like the whole beginning of this court case, right? Why are you filing a TRO? Why are you filing a TRO like 2 months after you file this court case? If you're claiming that you're going to be irreparably harmed, it seems like you would file this like a day or 2 after, if not immediately, alongside your initial complaint. Like why would you wait? Why would you wait? It hurts your argument. It undermines your argument. Quote, indeed, the very idea of a preliminary injunction is premised on the need for speedy and urgent action to protect a plaintiff's rights before a case can be resolved on its merits. What was their excuse? I already told you. Their excuse was that like one of them has cancer and is flying to Texas for treatment, and the other had pneumonia for 2 weeks. I'm not joking. I'm pretty sure the transcript for that initial hearing is literally it's somewhere on here. I don't know where. Fuck, do you have to buy it? Oh, it's this here. I probably have this on my other account, but it's a deeply unserious statement. But okay, anyway. To that end, while the movement must meet all 4 elements required to merit the issuance of a preliminary injunction, a showing of irreparable injury is the sine qua non, the sine qua non of injunctive relief. Hold on, how do you pronounce this?
So I'm not saying that's a sine qua non or
a sine qua non of injunctive relief. Even if plaintiffs establishes a likelihood of success on the merits, the absence of a substantial likelihood of irreparable injury would, standing alone, make preliminary injunctive relief improper. Plaintiff's success establishing likelihood. Okay. Such alleged irreparable injury must be neither remote nor speculative, but actual and imminent. So you can't just like, say like, oh, like maybe, oh, the transcript is there on the docket. Oh yeah, you can see this. It's April, so it's been filed. The parties have already met for the joint status report. That was already filed. I've got a scheduling order. The defendants have answered. And now last night, oh yeah, because they filed this TRO without even telling us that they were filing it. They just like dropped it. It's like, excuse me, what? We can't meet and confer before? And now last night I get a TRO based on facts that don't appear to be any different from the complaint. So I want to hear just very briefly as to why I should, this is the judge speaking, why I should entertain the TRO as opposed to just setting it down for a preliminary injunction. This is Joan, right? Joan Peters. I don't know who Schlump is. I know this one is. Well, Your Honor, I do apologize for the delay in getting that motion out. There are a number of reasons why that happened. One, and I hate to go into personal things, but Mr. Garcia was dealing with a cancer issue and going back and forth to Texas. I had pneumonia and I was out straight for more than 2 weeks, so we were really set back. That's just 2 of us. There's just 2 of us working on this case, and so that significantly delayed us. But there's also other reasons, which is that we were trying to gather affidavits from witnesses to bolster our evidence for the TRO and get, witnesses lined up for it. Unfortunately, what we have encountered, we have a number of women that have come forward to us, but then have backed out because they were afraid of retaliation. And that's what they've told us. And so we were not able to get these affidavits. We went with what we have now, which basically we went from 15 potential witnesses providing evidence down to the 1 witness in addition to the plaintiff, meaning that all of the people that initially DM'd them were probably fake. It was probably just like people making AKAs, sending them messages. And the real answer to this, the reason why this is such a deeply unserious response is, why didn't you have all these statements lined up before you filed the lawsuit? Pixie made her Substack, and then you filed the lawsuit a month later. Why not just wait another 2 weeks to get the statements? Like, this makes no sense. This is a nonsense response. The judge replied, this doesn't have anything to do with anything. This is not a class action. You filed on behalf of 1 woman. The TRO requested he remove the video of the 1 woman. And then there is a request with respect to whether or not he is doing anything to destroy evidence in this case. I don't know that that's a TRO. I think that's more akin, you can file a motion with respect to that. None of this sounds in TRO to me. Obviously the medical issue, I hope you're doing better. But yeah, they got kind of roasted on this, but okay. Okay, accordingly, so now the judge says, accordingly, we will begin by analyzing plaintiff's showing of irreparable harm. So this is the first element that needs to be met for their preliminary injunction. As described above, plaintiff commenced this action on February 18th, 2025, and subsequently filed her motion for a TRO and preliminary injunction on April 2nd, 2025. This matter, however, ultimately stems from defendant's alleged sharing of the video several years prior to the commencement of this action, whether only with Rose or 2 additional persons. Defendant theorizes that it was a hack of Rose's Discord that led to the leak of the video, and thus it's subsequently being uploaded to Kiwi Farms on November 29th, 2024. So, the magistrate judge includes this down here. At the TRO hearing, plaintiff's counsel indicated various health issues as factoring into the delay, but primarily offer the following. We have a number of women that have come forward to us but have backed out because they're afraid of retaliation, and that's what they told us, so we were not able to get these affidavits. Remember what we have now, which basically we went from 15 potential witnesses. Okay. The court found unavailing plaintiff's issues as to other witnesses. That doesn't have to do with anything. This is not a class action. You filed on behalf of one woman. Remember, Pixie wants to keep sticking like other things in this just to defame me, basically, because I can't sue for defamation for what's in a lawsuit. So it's just to attack my reputation. But okay. So from the allegations in plaintiff's timeline, even if we look at only the closest incident to the present, the video being uploaded to Kiwi Farms on November 29th, 2024, plaintiff waited roughly 5 months to file her motion for preliminary injunction and provided no convincing justification for the delay. That fact alone suggests that plaintiff's alleged harm, even though it may be tangible and compensable at the conclusion of litigation, is not irreparable, as that term is applied in the context of a preliminary injunction motion. This is quoting another case, affirming denial of a preliminary injunction where plaintiff failed to offer any explanation for his 5-month delay, and the record did not indicate any justification thereof. Absent compelling reasons shown otherwise, an extended delay in moving for relief to address irreparable harm undermines that burden in the first instance. Importantly, plaintiff's request for a TRO was denied for similar reasons at the April 4th, 2025 hearing. In fact, plaintiff's counsel even agreed that most of the damage has already been done. Don't say that. If you're trying to seek a TRO or a preliminary injunction, don't ever say this, that most of the damage has already been done. You're undermining the first element of why you're trying to look for a preliminary injunction. Why would you ever say this? Don't ever say this. Because if the most damage has been done, then there's no point. Then we might as well just wait for the court case to proceed, right? This is such a dumb thing to say. Which accords with the fact that 3 of the 4 elements of plaintiff's requested preliminary injunction are targeted at defendant's alleged publication and or distribution of intimate images, such videos, or related information, i.e. the video, which is the crux of plaintiff's complaints or claims. As to the 4th item of plaintiff's requested preliminary injunction, addressing alleged spoliation of relevant evidence, plaintiff's counsel then proceeded to explain at the April 4th, 2025 hearing that the ongoing issue is that we keep receiving evidence of destruction of evidence. We are trying to compile enough evidence to file a motion for spoliation. It is now October of 2025, and there is no such motion on the docket. Despite that being the then existing ongoing harm plaintiff was ostensibly seeking to stop. In other words, they are lying. They keep saying that I'm deleting evidence and hiding shit. Where is your motion relating to this? Where is your evidence relating to this? You have none, because I'm not doing this, and it is a fucking lie. They just keep bringing it up in every single fucking filing they have. But here we are in October of 2025, and they have absolutely nothing. But even putting aside for a moment plaintiff's counsel's statements at the TRO hearing, the allegations in plaintiff's motion as to an imminent risk of further non-consensual disclosures of intimate images of herself by Bonnell and further humiliation from the same also do not convince us of ongoing harm. In her motion, plaintiff claims that it is the imminent risk of further non-consensual disclosures by defendant that creates ongoing harm sufficient to merit a preliminary injunction. This is their footnote number 5, which was related to... Oh, right here. Ongoing harm, plaintiff was... Okay. Plaintiff's original and amended complaint contain identical allegations regarding spoliation. On January 1st, 2025, aware of an impending lawsuit of potential criminal investigation, Bonnell starts destroying evidence, including deleting messages between him and plaintiff. On January 23rd, 2025, Bonnell receives a letter from plaintiff's counsel informing him of plaintiff's intent to sue and demanding that he reserve all evidence. At the TRO hearing, the court expressed doubt as to the plaintiff's characterization of the events as spoliation. Quote, and this was the judge talking to them in the first hearing. And I will tell you that even as you've pled it so far, we'll see what the defense says, but if I got sued for distributing the materials about a woman, and I may have done that with other women, then I might say to myself, maybe I shouldn't do that anymore. Let me delete that. Let me take that back. Let me not do these things I'm being alleged that I'm doing, because maybe these are bad things I shouldn't be doing. That may be one of the things that's going on. That's not spoliation. I don't know. So this was the judge expressing doubt even to what they were claiming is like, I mean, there could be valid reasons to delete certain things, but again, it's up to them to file a motion showing otherwise. They haven't. They have filed 50 million other fucking motions though, but okay. But albeit very distressing, the video at the center of this dispute is online. Plaintiff acknowledges as much in her amended complaint, citing several websites that are currently hosting or have hosted and then removed the video. Quote, despite efforts to have the video removed from different sites, they're still there and available to the public, so my humiliation is ongoing. And although not the focus of plaintiff's actual claims, or in large part the parties' briefing, to the extent that any communications between the parties are publicly available, including several exhibits submitted in support of the parties' briefing, Those two are already online. And further, both plaintiff and defendant have engaged in online commentary regarding this case, including as to their version of the events and or purposes. So Pixie's Substack, I said this in the very beginning, her posting all of that is going to undermine a whole bunch of her arguments regarding this irreparable harm stuff or regarding how injured she might be about all of this, because she publicized the fuck out of so much of the stuff related to this case. And it undermines a lot of the statements that she's made publicly, undermines her claim that there is some irreparable harm that could be suffered or any of the other things related to this case. It's like you should have never made that Substack. I think even if they survive the 12B1, even if they survive the motion for summary judgment, even if they win in court, when it comes time to assessing damages, these statements will still come back to haunt her. Even if they made it all the way to the end, and even if they won on a jury here, assessing damages is going to be undermined by these statements. We do not doubt plaintiff's testimony that she is distraught because of these events. To the contrary, we find her testimony fully credible in this regard. But as her counsel stated at the TRO hearing, the damage has already been done as to the video and related statements, and was at the time of the TRO hearing on April 4th, 2025. The footnote for this: plaintiff does allege that during the only time she had been on sexual relations, he recorded videos, plural, but as to the risk of ongoing harm regarding defendant continuing to share videographic material online, the declarations to... Oh my God, this was so good too. Oh my God, thank God. Okay, but as to the risk of ongoing harm regarding defendant continuing to share videographic material, the declarations to which plaintiff cites, this is the Hannah one, allege only that he shared or sought to share the video. Further, while plaintiff's operative complaint includes the videos in her claims, the allegations regard defendant's alleged sharing of the video. It is unclear if some references to the plural form are even intentional, as they would seem to contradict prior submitted exhibits. Contrast, on or about January 26, 2025, Hannah Brooke, a follower of Bonnell, contacted plaintiff and informs her that even after the videos were published on November 29, 2024, Destiny/Bonnell offered to send the videos to her, emphasis added, with... On or about November 2024, I became aware that a sexually explicit video that included Destiny and another streamer, Pixie, had been published on the internet. On January 9th, 2025, Destiny offered to send me the video, and then it's quoting my text here, if you want videos. Date discrepancy aside, there's no actual indication that, even if there were an offer to send multiple videos, that they would include plaintiff. One, the unsworn statement specifically references the video, singular, and two, per plaintiff's own allegations, defendant had other videos of sexual encounters not involving her. And the videos of Bonnell sent to ABMC on the shared Google Drive link included one of the video plaintiff. ABMC recognized the video of the plaintiff in the video by her face and hair, emphasis added. So this is that whole this Hannah girl tried to DM me to fucking entrap me or some bullshit, I guess. And she also deleted half her logs, by the way, and the evidence that she submitted. But like, I never offered to send this chick anything related to Pixie ever. I was making a reference to stuff that was already on Kiwi Farms. I'm so glad that the judge recognized that this bullshit fucking declaration that these guys submitted had nothing to do with any of the Pixie shit. Oh my God, thank God. Anyway, okay, back into this. Sorry, we're almost done with this. We do not, okay, testimony, this was time, the tier hearing, okay. There is then no irreparable injury, a need for speedy and urgent action that would trigger the issuance of a preliminary injunction here, because the damage is already done, as their own lawyers have basically already said, right? Additionally, mere injuries, however substantial in terms of money, time, and energy necessarily expended in the absence of an injunction are not enough. The possibility that adequate compensatory or other corrective relief will be available at a later date in the ordinary course of litigation weighs heavily against a claim of irreparable harm. When it says mere injuries, even if the injury is great, as long as it is reparable, or as long as you can be made whole after the case ends, right? Then it doesn't matter how bad the harm is. You have to show irreparable harm. There is now a confidentiality agreement and protective order that governs discovery in this case, including how to handle confidential information. Should plaintiff discover evidence of spoliation, she is able to file a Rule 37 motion or otherwise request relief from the court. Plaintiff has also attested that she has made efforts to have the video removed, and plaintiff has already filed several motions in this case seeking relief from the court as to, among other things, the video being hosted on a third-party site, public statements by the parties and their counsel, and recourse for alleged sanctionable statements and actions by defendant. We raise these motions and actions not to comment on their merits, but because by doing so, plaintiff is actively seeking avenues of other corrective relief for alleged issues that track her injunction request, further weighing against her claim that she is facing irreparable harm that cannot be ameliorated by any other means. So basically saying that, like, well, you're saying your harm is irreparable, but look, you're filing motions to get money and to do other things related to these things, so clearly they are irreparable, right? And to the point of compensatory relief, Plaintiff herself has acknowledged on social media that a primary aim of this lawsuit is inherently financial. So I believe when it comes to tort, when it comes to people suing other people, I think there might be other forms, but I'm aware of two forms really. You have compensatory relief, and then you have, is injunctive relief a different one? Oh, maybe injunctive relief is a one. You stop people from doing things. And then you have, what am I thinking? You have compensatory damages and, punishment. What is like the punishment? Like somebody fucked up really hard. What do you, it's compensatory and punitive. Okay. And punitive damages. Everybody is like super convinced that like, you know, once Pixie destroys me in this case, that she's going to get like millions and millions of punitive damages. Punitive damages are relatively rare. I think less than 10% of cases. Punitive is like, not only did you like break a particular law, or not only did you like violate somebody as per some civil cause of action, but you did it like super maliciously, like a massive fucking piece of shit, horrible person, right? So one of the things I've said before, when you read a lot of these Doe cases, like the defendant is unhinged. Like in one of the cases that they cited in an earlier motion, they cited a lot. It's either Doe v. McCoy or it might be Doe v. Unknown Persons. When they make their continuous publication argument, they're citing this case. That guy published 11 videos of him and his ex having sex on motherless.com. And he made those videos available until the plaintiff sued him, right? So it's like obviously super malicious, obviously trying to fuck with defendant hardcore, acting in response to, I think he lost his kids or something, or lost in some family court hearing, like was like, so like that might be a case where like, okay, well, punitive damages might be necessary because you've fucked around so fucking hard that like now the jury's gonna fuck you super hard, right? Because you're, yeah. I don't know if there's like a better guidance for punitive stuff, but anyway, and to the point, so compensatory is just like compensating you for direct damages or for damages spelled out in a statute or whatever. Statutory relief, I think. Plaintiff herself has acknowledged on social media that a primary aim of this lawsuit is inherently financial. So Pixie's tweeting out, I don't know what you're specifically referring to, but Steven is a multimillionaire, and I wanted to lose so much money as a result of this that every time he thinks of the word nude, he cringes at his mistake. I truly believe if the cost isn't high enough, he will do this again. My goal here is not public humiliation of Steven or even all the money in the world. It's him receiving such a financial hit / penalty that he will permanently learn his lesson. So the problem with her tweet here is what you're basically saying is, oh, so the thing that will stop the defendant from his bad behavior is just a big financial harm. There's nothing irreparable about that. This is something that the court can obviously provide at the end of the case through compensatory relief or through punitive damages, through punitive relief. So like if you're tweeting out like, I can make him stop by having him pay enough money, okay, well then why are you looking for a preliminary injunction, right? That's not irreparable. By definition, there is a way to make you whole, or there's a way to, now this is also talking punitive and not really compensatory for her, but what is this? This is comparing, I don't know if this is relevant. Okay. And then that's linking to her tweet. Good one. Thus, plaintiff's alleged injury could, by her own words, be addressed by way of a legal remedy. Accordingly, and for the foregoing reasons, we do not find the plaintiff will suffer an irreparable injury unless an injunction issues. As the absence of a substantial likelihood of irreparable injury would, standing alone, make preliminary injunctive relief improper, we are empowered to deny plaintiff's motion solely on this finding. So failing 1 out of 4 would be enough, and that's, you could stop the analysis there. But he keeps cooking. But as to plaintiff's likelihood of success on the merits, we note that there is an outstanding question of whether this court has subject matter jurisdiction over this case. So as to like success on the merits, the court still doesn't know if they can even hear this case. That hasn't been like adequately resolved yet, which is pretty spooky given that we're 8 months into this. Plaintiff also adds that she has made a prima facie case as to her claim under 15 U.S.C. 6851, but that would be mistaken if plaintiff cannot show in due course that the conduct alleged is indeed covered by the statute. So prima facie just means that it, by the text, meets all the elements of the law. In my opinion, this is a fairly brutal statement because the judge's, my interpretation here is the judge is saying is that you have not yet shown that you've even established, this is a subject matter jurisdiction question, prima facie, you haven't even established that this federal law applies to the alleged conduct. So in due course means you have yet to show this, that the conduct alleged is indeed covered by the statute. And were it not covered, because plaintiff's assertion of federal question jurisdiction hinges on the applicability of 15 U.S.C. 6851, it is possible that we do not have subject matter jurisdiction over plaintiff's case. At this stage, we cannot agree that plaintiff has demonstrated the likelihood of prevailing on even one cause of action, because if 15 U.S.C. section 6851 does not cover the alleged conduct, plaintiff necessarily cannot prevail on that claim. And two, if we do not have subject matter jurisdiction over plaintiff's case, we then cannot even opine on whether plaintiff would prevail on her state law claims. Ultimately, as with irreparable harm, we would be empowered to deny plaintiff's motion solely on this finding as well. According here, if you're unable to establish likelihood of success on the merits, okay. Nonetheless, as to the final two elements of the preliminary injunction analysis, plaintiff has not shown that she, under the circumstances, is at risk of irreparable harm as a result of any alleged continued dissemination of her intimate visual depictions of private information. And thus, any injury would not outweigh the damage of unduly imposing an injunction. Since she hasn't been able to show irreparable harm, it would obviously be burdening me or any other party to be enjoined. And since she can't show any harm as continuing of this, then how can she enjoin anyone else? Further, as to public interest, plaintiff argues that the congressional intent behind 15 U.S.C. 6051 creates a public policy against non-consensual sharing of intimate images. Even if true, plaintiff's argument is inapplicable if the alleged conduct is not covered by 15 U.S.C. 6851. In sum, plaintiff has not clearly established the burden of persuasion as to the four requisites. Her motion for preliminary injunction is denied in whole, but that denial is, of course, without prejudice to the ultimate adjudication of the case, which may or may not require permanent injunctive relief if legally sound. So obviously, if she wins the case, then there might be injunctive relief, obviously like not sharing intimate material or whatever else. But, conclusion, for the foregoing reasons, plaintiff's motion for preliminary injunction is denied. The motion is adjudicated by order as the motion is largely denied for procedural grounds and not on the ultimate merits. But injunctive, obviously the case is still decided. This is just denying the preliminary injunction, not like deciding any of the underlying merits of the case. But injunctive relief generally is addressed by a magistrate judge via report and recommendation, because the litigant would be entitled to do to de novo review from the district judge if such review is sought. So they could, for instance, like appeal the preliminary injunction and ask. De novo means like from the beginning, I think, like a brand new legal review from the district judge if they were unhappy with how the magistrate judges ruled. The entry of this order thus does not foreclose any party from appealing this order, which would then be treated as a report and recommendation by the district judge under local magistrate rule 4, I guess. The parties retain the right to de novo review if such an appeal is filed. It is further ordered that as to any links to images or online documents and an unannounced reference link must be included as exhibits to filings for security reasons. The court will not open random links to Imager or Google Drive. Should a party believe any such exhibit should be sealed, they may file a motion asking leave of court to file it under seal, as with any other filing exhibit. I think because they keep including links. I think like Google Drive links are like motions, Imager links to their filings instead of just uploading them as exhibits, which is funny, but done and ordered. Okay. Compared to when this entire thing started, how are you feeling overall? Is the lawsuit going better or worse than you expected? I mean, I guess it's going, in terms of like the merits, it's going as I expected. In terms of the process, I underestimated, I guess, in the beginning, like how much a bad faith party could theoretically draw things out. I guess I'm just not aware. I don't know if maybe it could be worse, but I guess, actually, sorry, there's one more quick thing to go over. This is just wild to me. This was like a proposed order they sent us a while ago. I didn't think they'd actually file it. I thought they were just memeing on this. So in the beginning stages of this lawsuit, so listen, me and Melina had a pretty, bad split, rough divorce. I don't hold any ill will against her or whatever. Obviously we had our disagreements at the end of our relationship. I'm pretty sure she fucking hated me at the end of our relationship at the beginning of this year. So if she's not like cooperating with Pixie's legal team, then my guess is she has some reason not to. If I had to guess, now I don't know for Melina, but my guess is going to be Melina probably just wants to like move on and not be involved with any stuff related to me, because she just wants to move on with her life. That'd be my guess. This is typically the kind of person that Melina is, right? Which is fair, right? I'm moving on with my life. She's moving on with her life. However, I don't know, again, if she's not cooperating with them or if they're like going hardcore, meme lord. They filed a motion yesterday, 2 days ago, 3 days ago, Plaintiff Jane Doe's motion for letter of request for international judicial assistance to compel discovery from Melina. Also, one thing, I understand that they don't have to do this, but like I will say, and I genuinely fucking hate Pixie for this because I think it is so fucking disgusting, and she's done this multiple times to Melina and other people, is Pixie felt it necessary to protect her identity, even though she publicized so much of this and she wanted the publicity from this, she wanted to be public about it. She made the attempt to file her name as a Jane Doe, right? I don't think she gives a fuck about any of her information being out there. She's just trying to catch me trap me on like naming her name, basically. Because clearly she doesn't give a fuck being associated with this. In their own fucking motions, like her fucking picture is literally posted, in one of their own exhibits. Like, what the fuck is wrong with you? I don't like that she keeps full name dropping Melina in all of her filings when, like, I'm pretty sure she doesn't want anything to do with this. Why don't you file her name at least under seal? Why do you keep bringing her full fucking name up in all of this? But whatever. That's wild to me. Plaintiff Jane Doe, buying through the undersigned counsel, hereby respectfully files this unopposed motion for the issuance of a letter of request. So initially we weren't going to oppose it, but based on all the shit, they always like put shit in here that they don't send to us. They never send us the original motion. They got called out in this, by the way, before for saying that like, oh, well, here's an agreed upon motion. But then, oh, I think it was for the protective order and the sealing of stuff. But the motion they filed with the court is not the same one that they send us that we agreed to. They file a different thing than what we agreed to. I was like, wait, what the fuck? And I'm pretty sure they've done the same thing here. So then we have to oppose it. We're like, well, hold on. We didn't agree to all this shit. What the fuck? This happened with their protective order bullshit before. And the judge commented on it, thank God. So they're filing this motion for the issuance of a letter of request to serve a subpoena to testify and produce documents on Melina, my ex-wife, a resident of Sweden, pursuant to the Hague Convention on the taking of evidence abroad in civil or commercial matters. In support thereof, plaintiff states as follows. So they're trying to get the international, pursuant to the Hague Convention, I guess a court in The Hague, to compel, to submit a subpoena through them to Sweden to try to compel Melina. I don't even know, first of all, if she can be compelled, because I think we were married through I think from the beginning of 2021 to the end of 2023, 4? I have to go find my documents, but I don't even know if she can be compelled because of stuff related to that. I don't know what they would even be looking for, because according to Pixie's own testimony, like, obviously I could share anything with Melina and this would have happened back in 2020. This is such a stupid thing. But the only thing I could imagine is if this were to get approved, which I don't think it will, but if this got approved, my only worry is that somehow this manages to add like 2 years onto my case, because I can't imagine how long it would take to go to The Hague to get a subpoena. They would have to retain local counsel in Sweden. That local counsel would have to serve Melina. She would have to respond to any subpoena, go back and forth. Like, yeah, I don't know. That just seems like insane to me. But a letter of request, also known as a letter rogatory, is a document issued to take evidence specific with a foreign jurisdiction. Letters of request are the means by which a court. I didn't even read this whole thing. Video was later obtained from one of these recipients and uploaded on the website. Individual with screen assault tiny leaks. Oh, they finally stopped naming the individual websites. Good job. Additionally, video is posted on social media about the video. Videos posted on social media about the video were viewed over 90,000 times. The viral leak made plaintiff feel depressed, humiliated, and suicidal. Okay. Relevant procedural background. The sought-after discovery from Melina Chadarina Emmy Goranson is relevant to the claims of this action, will likely prove highly material to the prosecution of this action, lead to admissible relevant evidence, and is proportional to the needs of this case. They're a former spouse of the defendant and is uniquely positioned to provide evidence of the conduct complained of in the AC, what is that, amended complaint, as well as similar conduct that she was a witness to. By way of example, Goranson is the recipient of certain sexually explicit materials involving plaintiff. Goranson is expected to corroborate plaintiff's allegations, including those allegations regarding Bunnell's lack of consent to disclose the video. How, in what way, what? If any of this was true, why not just they could just take statements from Melina. It sounds like she either was unwilling or unable to provide these, so I don't know why Yeah. Destiny, does it ever bother you that if this case came out in like 2018, you'd have every single anti-SJW skeptic commentary bro backing your shit because this is clearly an unironic like fake Me Too case, lol. Oh, Shuon had ray gun. I mean, yeah, I don't know. So will the case finish within a year? The trial dates for this would be, I believe it's set for May of next year, as long as they can't delay it at all. But I might be retarded, but I don't think there's anything to do with The Hague, like the court. It's just mentioning the international law that enables them to subpoena someone in Sweden. Oh, like there's not like an actual court that they have to go through in The Hague where everybody's like a convention. Oh, maybe that might be true. Maybe they're just referencing like a convention and there's not like an actual court that they go through internationally before going through Sweden. So they would just sort of go through. Maybe it's possible. I have no idea how any of this works. So, Forest allows the transmission of letters of request from one signatory state to another without request outside the U.S. Hang on, it's not the first. Well, Melina can still oppose it, so yeah, I mean, like she could, but also like I feel bad. One, I do feel bad for everybody involved in this. Obviously, it sucks for everybody involved, Melina included, especially because I'm sure again Melina wants to move on with her life. So like, if Melina is going to have to start to incur like lawyer fees to fight against it, that's just a really shitty position for her to be in. Yeah, it's just, yeah, all of this is cringe. Moreover, Goranson is, or is believed to be, another victim of Bunnell's unlawful conduct. Finally, Goranson would testify to Bunnell's character as irrelevant to this case. Okay. Indeed, Goranson is expressly mentioned in the amended complaint as a relevant witness. Yeah, but she hasn't provided any declarations or statements, so who the fuck cares that you're mentioning them? Alternative means of obtaining such evidence are unavailable. Moreover, this evidence cannot be obtained from means because Goranson's knowledge of facts relevant to this case is unique and central to plaintiff's allegations. I mean, not really. Again, anything would have been before the Cardi statute. Like Pixie herself has already testified that, well, she's given 3 different answers as to whether or not I could share stuff with Melina. So none of this even is relevant to anything. However, even if it were available by alternative means for the sake of argument, the mere fact of an alternative method for obtaining the documents is not proof that it is necessarily an effective or efficient method for doing so in this case. Taking evidence abroad in civil or commercial matters. Yeah. Yeah, this is just fucking insanely memey. Cringy. Wild. I don't know. None of Melina's testimony really establishes subject matter jurisdiction, though, right? No, it doesn't. Unless Melina were to testify to me, like, doing something within the Cardi statute date, which she wouldn't, because, well, one, because I didn't, and because this is just, like, it's such a Hail Mary. But, I mean, like, this whole case is a fucking Hail Mary, so. Anyway. So, are you opposing this motion? Yeah, I believe we are. Anyway, fun times. That's my life. I'm glad the judge is making rulings now. I think today our response to their reply to our motion to dismiss is due, so we'll be doing that. And yeah.